Thank you. All right, you're Derica Johnson. And Ms. Johnson was previously in court, entered pleas of true in a motion to revoke probation to counts 1 through 4. On probation for aggravated assault causing serious bodily injury, and that was a 6-year deferred probation. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Are there any additions or corrections?
No, Your Honor.
And there was no agreement, correct? Unagreed. Also, just for everyone, and if we can get copies if you guys need it, I am also reviewing jail incident reports as well. Mr. Rojas, you may proceed.
Judge, as the court knows, this is Ms. Johnson's third motion to revoke. She's been given opportunities in the past to comply with ISF, MRT, and some mental health counseling. She hasn't taken advantage of all those opportunities. She has some CPS cases going on. She's kind of doing double load casework. She's got some CPS cases in Harris County. She's taking some classes through there, and that had been her focus up to now, is trying to get her kids back. I've discussed this current motion with her. She understands that the options the court has this morning are to revoke probation, send her to prison, or to try one more time and get her some help through either ISF or SafeP. In discussions with Ms. Johnson this morning, she I think the option that she would rather do is to ask the court for some mercy and give her the lowest amount of time in prison possible. We would request something in the neighborhood of 2 to 4 years. She, at this point, doesn't feel that she needs a drug treatment, and the ISF program is this thing that, well, she was removed last time because she's pregnant. She's not pregnant right now, so I think this would be the perfect time for her to get ISF and get that help. But she tells me that she doesn't want it. She would just rather go to prison and get this case over with.
Ms. Malfino?
Judge, I concur with Ms. Lopez's updated PSI. It's very thorough and goes through every opportunity this individual has been given by the court. It's a shame she doesn't want the help. Really could help her. I mean, if she was using last time while she was pregnant, she's obviously somebody who has an issue that needs to be addressed. But if she doesn't want the help, I guess she shouldn't take up someone else who wants the help spot. And so I think revocation is appropriate with something in at least in the mid-range.
Let me look real quick. Let me see what this.
Looks like she had one prior MTRP and was given 120 days sanction at that time in 2023.
I mean,
the facts of the underlying case, I think she threw a bottle at a girl and waved a knife at another. We pled and dismissed from originally. I think nobody was injured, judges, just threats basically.
Well, she threw the bottle attempting to hit someone else, but it hit someone, but it hit someone else in the head. Well, there's no accidentally. You meant to hit somebody with it. You just hit the wrong person. Right? No. No, because Ms. Johnson, you have been coming here now way too long and been given every single opportunity to stop talking over me. Because right now, what you're looking at that I can do is give you between 2 and 20 years in prison. And the more you talk over me and are disrespectful, the higher number that's going to get. Do you understand? You have been, I'm not even sure how many times now that you've been in here pregnant, using drugs while you're pregnant, while we're trying to get you help. You have 5 kids that you have no custody of. It's the jail incident reports are ridiculous. And then you want to come in and say, I just want to get this over with. Give me a couple years in prison, which you probably have credit for, which is absolutely not what I'm going to do. Give me just a second. The fact that this is kind of your 4th shot at it makes me wonder what I was thinking the prior 3 times. And really, All right, Ms. Johnson, at this time I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault. I'm going to sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit for any time that you've been in custody that the law gives you the right to receive. Am making an affirmative finding of a deadly weapon in your case. I'm handing you the trial court certification that shows this was not an agreement. You do have some rights to appeal. You can talk to Mr. Rojas about that. I'm also handing you the trial court certification, the written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. Good luck to you. You can go back with the bailiff. Ms. Holmes, you may proceed.
Thank you, Your Honor. As the court can see, Mr. Delose is an amputee, in which he suffered from injury a few years ago. Your Honor, we're requesting if the court would consider probation. I believe that Mr. Delose would benefit from being on a mental health caseload as well. He does suffer from some mental issues that I feel that would be beneficial if he could receive care through either MHMR or Spindletop. He understands that he does have prior convictions, so as a convicted felon, he cannot possess a firearm. And he understands that moving forward, no matter what situation he's in, he cannot have a firearm. Your Honor, he does have 2 children that he would like to be better involved in their lives. One of the main issues that I see in the PSI is education. He has a 6th grade education. I think it would also benefit if he would be allowed and participate in the GED program through the probation department as well, to help him to develop some skills so that he can make better decisions and get his high school, at least minimum high school equivalency. There isn't much history in regards to substance. With regards to substance abuse, it looks like maybe alcohol that he drinks on occasion. And he has no problem, it says in his recommendations, to avoid any association with the co-defendant, Ashley Faye. And as I stated, Your Honor, he would be willing to adhere to any referrals or treatment plans or directives that probation may recommend. And so we are requesting probation.
Thank you, ma'am. Mr. Nichols?
Your Honor, he has 3 prior felony convictions, 1 for being a felon in possession of a firearm, 1 for aggravated assault with deadly weapon. He should have been habitual. I took into consideration his health issues when I made the offer of an 8-year cap. I don't know that he deserves any more consideration for what has happened to him. You see his gang history, his criminal history. I think 8 years is appropriate in this case.
And I'm sorry,
Mr. De La Rosa, you wanted to say something?
I do got priors now, but I don't know like juvenile stuff like that.
So in 2015, you were not a juvenile.
2015, that when that conviction was like I think 7 years.
That was your conviction for unlawful possession of a firearm by a felon. And you got a 2-year sentence.
Yeah, no, but I did my time and I did parole. I did good behavior.
Right. So you should have learned. Not that you can't possess a firearm. I mean, and Ms. Holmes is doing the best she can, saying that, you know, you understand and that you can't possess a firearm, but you've already gone to prison for that. So
I was at the wrong place, wrong time. Now, I mean, it wasn't my position due to the fact that I am a felon. I'm not denying it, but you know, what I'm saying, I would deserve I feel like a second chance or something.
well,
I always keep like I want to get thrown in prison, come out when I'm 38 or something like that.
well, and I understand. Well, and here's the thing, Mr. De La Rosa, nobody wants to get thrown in prison. And what I do today isn't anything that I'm doing. It's where you've gotten yourself with your history since you've been a juvenile into being an adult, knowing that you cannot possess a firearm. You've got 3 prior felony offenses. One was when you were certified as a juvenile, that first one. And then if you didn't understand the law about deadly weapons, you should have, or carrying a firearm, you should have back in 2015. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Going to sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement I followed, so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, we know this now. I'm required by law to read this to you. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.